Boom. The judge doesn't waste a second. Straight into life advice that could save you 2 decades behind bars. This is the kind of opening line that makes you sit up and think, wait, should I be taking notes?
You're going to have to make better decisions from here on out. Everything that you do, you need to ask yourself, could it result in you going to prison for 20 years? If the answer in 23 CR 6906 stated Texas versus Tyree Joseph Ranford, could our parties announce for the record for the state?
Thank you, Wilkins, for the state, Your Honor.
Defense?
Monica Guerrero for Mr. Ranford.
And are you Tyree Ranford?
I am.
So here's the deal. He pled no contest, which, for those keeping score, means he's not admitting guilt but isn't fighting it either. And with a plea bargain in play, the chessboard is already set. But will the judge still throw in some curveballs?
All right, you entered a plea on September 28th of no contest, and also a plea of true to the enhancement. And we're now here for sentencing. According to the plea bargaining agreement, punishments be assessed at 6 years in the prison, and the state is silent on your application. Have both parties had a chance to review the PSI report?
We have, Judge.
Any objections?
We don't have any objection.
All right, anything you wish to say on behalf of your client?
So I explained to Mr. Ranford what the court's policy is, and that many people ask you, why would you ever want to be on probation in the 187th? Because when you mess up, you're going to prison, and that you make the probation conditions very, very difficult. I've explained all that to him, and I told him that you don't play around, that he will be drug tested, that he will be checked throughout this thing if you give him the privilege of having probation. He said he understood that, and he wanted to still apply. He also wrote a letter to you that he would like for you to consider to read. He thinks he would be a good candidate for probation because he's already getting too old to be messing around anymore, and he doesn't want to end his life having chronic back pain and trying to treat it himself. I don't know if you wanted him to read it to you or if you want me to tender it to the court.
If there's no objection.
No objection, Your Honor.
All right, and if I could see the letter.
This is a pivotal moment. Help for recovery or a hard prison sentence. And notice how the judge frames it as a choice. But let's be real, it's a choice with one very obvious better outcome. Or is it?
All right, anything else you wish to say, Mr. Ranford?
Well, no, ma'am.
All right, so sometimes I can give people choices, sometimes I cannot give them choices. It's obvious to the court that you have a drug issue, right? So if you want help for your drug issue, the court will give you help for your drug issue. Or if you would like, what I can do is I will sentence you to 3 years in the prison. Which would you prefer? Okay. There's an application for deferred adjudication. Then the full range of punishment will be open to the court, which is up to 20 years in the prison. You understand?
Yes, ma'am.
All right, I'm going to sentence you to 8 years deferred adjudication. There's to be regular reporting by Zoom or in person. There's to be the UA hotline. This is to run concurrent with County Court Cause number 698064. Take in consideration 707108, NITMAG numbers 709-145, 722-670, grand jury number 804578, proof of employment within 30 days of release, no employment as a home health care provider or with minors. There's to be no unsupervised contact with minors. 200 hours of community service restitution. Do you have any children?
No, no.
Will you be living with someone if you're released?
Yes, Your Honor.
And who would you be living with?
My father.
Okay, just 1 second. Let me see what the TAP evaluation tells us. All right. There's going to be a transfer to SATA. So you're going to stay in custody until you transfer it to SATA. And we can also do a referral to felony drug court. Felony drug court has a wait list, so they're probably not going to be able to accept you. So you'll be going to SATA. And upon release, I'm going to want 90 sober meetings in 90 days. Field visits, 1 time per month for 4 months. And then within probation's discretion thereafter. Probation, is there anything else he needs? All right, is there anything else you need from the court to be successful?
No, Your Honor.
All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
All right, good luck to you. We can go off the record. You're going to have to make better decisions from here on out. Everything that you do,
Yes,
you need to
ma'am.
ask yourself, could it result in you going to prison for 20 years? If the answer is yes, don't do it. If the answer is maybe, don't do it. You understand?
Yes, Your Honor.
All right. And in this court, to be successful, your counsel probably told you communication is key. If you have an issue, let probation know. If you feel like they're not addressing it, you can always come to court. Okay. All right. Good luck to you.
Thank you.
Andy?
All right. Court is calling 2019 CR 10494W, State of Texas versus Angel Montoya. Can I have parties announced for the record for the state?
Shotgun for the state.
Defense?
Ed Piper from Miss Montoya.
Are you Angel Montoya? Going to show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that with your attorney? Did you understand it?
Yes.
Are you the same Angel Montoya who was placed on deferred adjudication in 2019 CR 10494W for the offense of possession of marijuana 4 ounces to 5 pounds on September 24th, 2019 for a period of 2 years?
Yes, ma'am.
State?
On or about the 27th day of January 2021, in Bear County, Texas, the defendant, Angel Montoya, did then and there fail to complete 50 hours of community service restitution in violation of condition number 14.
Plead to that, true or not true? Did you understand? I'm sorry. Are you waiving the other allegations?
Your Honor, the state waives and abandons the other allegations.
Any objections?
No objection.
Did you understand by pleading true to violation of condition 14, the court could find it true, grant the motion, find you guilty, sentence you up to 2 years in the state jail facility and up to a $10,000 fine? Knowing that, do you still wish to plead true to violation of condition 14?
Unsatisfactory termination sounds harsh, but in legal terms, it's basically probation's way of saying, we're done here, but we're not giving you a gold star on the way out. The interesting twist: she's already done serious time, and it might have turned her life around.
Court will find violation of condition number 14 true. Is there a proposed agreement?
Yes, there is, Judge. I've spoken with probation and spoken with counsel for the state, and we agree as well with the recommendation that her probation be terminated unsatisfactorily.
All right, what has she done?
Judge, what she has done is that while she was on probation, she had another incident out of Kendall County shortly after that. She spent 18 months in prison in Plain State in Dayton, Texas. She was recently released in July. And since that time, and having spent that time in prison, she's changed her whole way of thinking and doing. When she was released, she was put on UAs for every week, no problems. Now she's on random, no problems. I asked her if I offered her up today for you to prove to yourself that she is clean and sober. She's perfectly willing right now to step up and do a drug test.
All right.
She's just done with that life.
All right, based upon the probation's recommendation and agreement, the court will find violation of condition number 14 true. The court will terminate her unsatisfactorily. What is happening with 2022 CR 00?
And just when you think the docket is closed, boom, a pending case jumps back into the picture with new evidence. Remember, in the justice system, timing is everything, and so is the witness who finally picks up the phone.
5-4.
Judge, 2 days ago, Mr. Dunn and I spoke. I brought to him new evidence, not new evidence that we had found, but we were waiting to getting the evidence because the person that we were getting the evidence from was incarcerated himself. But I've had 2 conversations with him since then, and the information he is giving me is material and substantial to this allegation, and I am giving that information to Mr. Dunn to interview my witness.
All right. So with regards to the cause number 2022 CR 0054, if we can get a reset on that for November 30th.